Well, if you have a legal problem at work but don't want to file a lawsuit, you can always try arbitration. Tom Sinus joining us today to discuss how employers and employees use this tool to resolve some disputes out there.
So we're talking about this, Derek, because at the end of May, the United States Supreme Court issued a huge decision regarding arbitration and how it affects employees in the workplace. So let's start with the question you just asked. What is arbitration? Well, arbitration is a way to resolve disputes outside of the court system. It could be a process decided by 3 people, 5 people, 7 people. What it means is that the person pursuing the claim cannot go to court, doesn't have a jury trial, has to pursue their claim in this private proceeding, whatever it is, okay? And what it also means is that whatever happens in the arbitration proceeding is almost always binding, meaning if you don't like the result, you can't go to court and appeal it. You're stuck with the result. So what happened? Well, the Supreme Court of the United States was asked to consider what kind of limitations employers could put on employees in their employment agreements affecting their ability to go to court. And what a lot of employers have been doing is putting clauses in employment contracts that say that any dispute of any kind regarding the employment has to be settled through arbitration and cannot go to court. Now, why does this matter? Well, there are a lot of people who have not huge disputes with their insurance company. Maybe the claim, as it was in this case, was that they were underpaid overtime, you know, a little bit every week, which adds up, but for one particular person doesn't add up to be a lot. So workers would band together and pursue what many people know is called a class action. Well, the Supreme Court said no more of that. Employees cannot band together in the form of a class action to sue their employers in court if they have a mandatory arbitration clause in their contract. And what the court was doing here was resolving these conflicting federal statutes and said that employers do have the right to force arbitration on employees. The other thing that has happened over time, which the court affirmed, is that the employer can say to the employee, not only must you arbitrate, but you and only you alone can arbitrate. So you can't get everybody else together who may have a claim for unpaid overtime and arbitrate together. You got to go it alone. What's the practical implication of this? It's not cheap to arbitrate a case. And if you have a couple $100 or a couple $1,000 dispute with your employer, how are you going to be able to get legal representation to pursue that claim? It really poses a potential problem for employees trying to seek redress in the employment context. On the other hand, some people will say, well, arbitration is faster than the court system. But if it's hard to get there, a lot of commentators are saying that this decision is going to mean it's going to be harder for employees to enforce certain rights that they, or complaints that they have in the workplace.
Doesn't sound as bad also. Arbitration versus suing your employer, that's a whole different ballgame, I guess.
That's a different issue.
Where do we find you? I have questions for you.
Find us online, www.sinusdramus.com. Shoot us an email at info@sinusdramus.com. Give us a call in West Michigan, 616-301-3333.
Thanks, Tom.
Thanks, Derek.